Well, let the Federal Circuit handle it. That's the decision from the Fourth Circuit Court of Appeals about a royalty fight with North Carolina-based Honeywell. According to the Fourth Circuit, the case should be kicked to the federal level, which has jurisdiction over all patent-related lawsuits. Joining us now, Chief Legal Analyst Conleaf Rhodes, talking about this royalty fight. It deals with barcodes and how precise the language is and what courts even have jurisdiction. So, as you were teaching your classes, dumb it down to consider this an intro-level law class on patent law and how complicated it can be.
Nothing about this will be entry-level. This is in law school. This is in law school, you're either 1L, that's your first year, 2L, or 3L, 2 years where you would take civil procedure, most law schools. And so this is a more complex class. I can thank Dean Moore, who I had for civil procedure, that could help me understand this. She taught me this portion, and she also taught me how to make yeast rolls. So I remember both. But let's be clear. This is venue, SMJ, and PMJ. Venue, can this court, is this the actual place that the case should happen? Do all the defendants reside there? Did substantial portion of the incident happen there? And if that's correct, then venue's proper. Sometimes plaintiffs will say, or defendants will say, hey, you brought this claim, but venue's not proper. The court will dismiss it. Then you got PMJ, that's personal jurisdiction. That's this long arm statute. You learn about that for a number of weeks in law school. And that's, well, were there substantial minimum contacts with this state? Have they waived it? Do they have a domicile there? And if so, this court, do they have the ability to enter a valid judgment? And if the court can recognize that they do, then they can hear the case. But in this case, the one that we're harping on here is this SMG, that subject matter jurisdiction. You said kick it up to the federal court. It's already in the federal court. This is a federal circuit court that's saying, I don't even have the jurisdiction to hear this case. Why? Because I don't have that SMJ portion. I don't have the subject matter jurisdiction. This is the Fourth Circuit Court that was hearing it. They're saying send it to the federal circuit, which is totally different. Same federal portion. We have state, we have federal, but there is a specific branch even within the federal court that only hears patent cases. And that's what they said here, that we don't have the ability to hear this case. Why? Because in the 1980s, the courts recognized that we only want judges that hear these types of cases on a regular basis hearing these cases. Federal judges will normally hear, criminal matters. They'll hear civil breach of contract matters. But these patent judges, these folks that hear these trademarks, patents, and copyright infringement cases, they're specialized in listening to those types of things. So we only want these folks hearing these cases so that we can have consistent and uniformity with our court rulings. And so that's the circuit that they said needs to hear this case. And the funny part, when you look at the court's ruling, they said that the defendants opened up the door for this. If they never brought up the patent defense argument, it would have stayed in the Fourth Circuit. They said, look, it was originally a breach of contract. You guys had some patent issues in there, but defense brought up the patent issue. And when they brought that patent issue up, the court said, look, we have an obligation to not even hear this. We can't even go further with the argument. It needs to be heard in a different court.
Conleaf, obviously a lot of people know Honeywell. It's building in Uptown right there that we have behind you on the screen. This could cost them millions of dollars, even require them to give millions back that they've already said that they were owed. How particular does language have to be when you're talking about patent law? Because that's what the judges are saying here. It's like, okay, the language needs to be precise, because if it's not, well, then that changes who will get the money.
I think in this situation, Honeywell is okay. When I looked at this case, there were two court rulings already. Okay. You had a jury decision that ruled in Honeywell's favor. You had a bench trial, which that meant the judge made a decision, and there was no jury. The judge heard the facts. He was the trier of fact in that time, and the judge said, okay, I'll rule in Honeywell's favor. What happened is you had these barcode scanners that they were arguing about, and there was it can scan 2 barcode, T2D, or 1D. And what ended up happening is that company said, we'll pay Honeywell 7%, for every time that we use these type of barcode scanners. But right. They were deciding that the ones that only use 1 barcode, 1D barcode, we weren't going to pay them for that. Honeywell found out about it and said, hey, you guys are being funny with the numbers. You're not giving us money for everything. You owe us this amount, and they sued them. That was 2023, and the court, as I mentioned, ruled in their favor. So it seems like when this one goes to the Court of Appeals, because both are appealing, that Honeywell will ultimately still win.
There we go, breaking it all down there. Good news for Honeywell, and if you are looking to go to law school, that type of lesson is something you can get from Professor Rhodes. Conleaf, appreciate you, my friend.